Good morning, everyone. Can you hear me? I guess so. So good morning, good afternoon, or good evening, depending on which time zone you are connecting. Thank you very much for joining us today, and we welcome you here at BIICL. Whether you are in person, thank you very much for joining, as well as online. So special thanks to those who are rejoining after sharing their time and thoughts at the roundtable that we held on this topic under Chatham House rules about a month ago, and also to the new ones that saved their time for being here today. Continuing with the notes of thanks, I wanted to extend special thanks to the Embassy of Japan and the Japanese Ministry of Foreign Affairs for their collaboration and support. And here at the Institute, many thanks to my colleague Christine Hausler, Jean-Pierre Gauci, Konstantinos Yalourides, Yarik Kirvoy, and of course, Iris Anastasiadou and Anna Darnopik, for the much appreciated help during the organization of this conference through ideas, contacts, suggestions, comments regarding the program and speakers. Really grateful for their support and insights. Last but certainly not least, special thanks to the events team here, Bradley, Liam, Carmel, and Bart, who took care of the technical side of things, registration and promotion. So as regards the structure of the event, after a brief presentation of a paper, which is still in a draft version, a paper that we have developing on the topic of today's conference, you will be hearing today two eminent panels discussing aspects related to the link between the rules-based international order and public international law. First, from a general perspective, the first panel will be chaired by Professor Roger O'Keefe. He's joining online. Hello, good morning. And then from a sectoral or topic-based perspective, with also some insights on the views, perspectives of the Global South, Africa in particular. The second panel will be chaired by Professor Bankole Sodipo. He's also has joined online. Let me now start introducing the topic by saying that we often hear the term rules-based international order in political statements and declarations, which prompts questions about the meaning and the scope of this concept. Most recently, in January of this year, there was a discussion, a debate that took place at the UK House of Lords on the rules-based international order, where the Secretary of State for Foreign, Commonwealth and Development Affairs was questioned on the steps he's taking to champion the rules-based international order. The discussion, if you go through the discussion and read the comments and the exchanges, the discussion clearly highlighted differing views on the understanding of championing the rules-based international order and upholding public international law, especially with regards to refugee rights. It was clear from the discussion that sending asylum seekers in Rwanda was considered as championing the rules-based international order, and that refugee law obligations were not really relevant and were considered as obsolete, quoting someone from the discussion, the Secretary of State actually from the discussion, things like the Refugees Convention were written for another age that requires some fresh thinking. When we hear the term rules-based international order, as international lawyers, we are inclined to understand the rules-based international order concept as equivalent, as a synonym to international law, as the political equivalent maybe of international law. However, at a closer look, as some distinguished authors have highlighted, Professor John Dugard, former chairman of a commission of inquiry on the situation of the human rights in Palestinian territories and former UN Special Rapporteur to the UNHCR, for one. So according to these distinguished authors, invoking the concept of the rules-based international order may be a deliberate choice in some occasions to allow governments to occasionally bypass their international law commissions and commitments and be able to pick and choose rules depending on changes to the political situation. So the paper, so we wanted to first discuss the meaning of the rules-based international order, this concept, and especially its relationship to public international law, and then spell out the reasons and conditions when such order is beneficial, which rules. The concept of a rules-based international order refers to a system in which countries have dared to establish norms, treaties, agreements to cover their interactions. It seeks to establish a fair, just, open, and predictable system of governance on the global stage in regions that are often characterized by diverse cultures, histories, socioeconomic challenges. Pursuing the rules-based international order is crucial for fostering stability, promoting human rights, and facilitating sustainable development. So, however, rules are not neutral, but reflect the interests and values of the states that sustain them. So the concept historically refers to the rules, norms, and institutions that were assembled in a coherent system of global governance in the immediate post-World War II era, and became then fully globalized in the aftermath of the Cold War. However, it has also been argued that there is no single rules-based order or rules-based system, but there are at least three of them. This view is put forward by Professor Chalmers. There are three distinct orders, one stemming from the post-1945 international settlement, the universal security system, a universal economic system is the second, and the more, according to his view, exclusive Western system. These three systems operate alongside another system, which is a system of major power relations. Each of the systems reflects power-based bargains between the members, and there have been tensions between such systems. So you can see here the different views or what is being discussed in literature on this topic. In essence, the emphasis that lawyers and political scientists and politicians place on rules is different, and this is our point, echoing the idea that was put forward by John Dugard. The use of the term rules-based order without an explanation of what it is meant may be dangerous, especially if the concept is employed to replace or promote a system that is only partially or selective on the commitments of international law, and which may ultimately weaken public international law. This has prompted scholars to raise the question of the choice between us, international law, or a rules-based international order, citing the title of an article, again, by John Dugard, or an article which addresses these issues, or citing another title from another author, ditch the rule-based international law and plead loyalty to international law. The rules-based international order and plead loyalty to public international law. In the absence of a global enforcement authority, it is incumbent upon members of the international community themselves to work together in establishing the rules on the one side and upholding them. And the rules-based international order concept underscores the interconnectedness of the world, and but it is only if it is premised on public international law principles and institutions that it provides an opportunity to shape a more inclusive and equitable global order that reflects the aspirations and contributions of all nations. While there is no legal rule or principle of public international law that has gone unbroken, nevertheless, the adoption of the treaties has thus far led to relative global stability, since the adoption of such rules and the establishment of the institutions following World War II. Despite challenges to the rules of international law, it is important to remain clear about what are the obligations of states under public international law, and so that violators can be held accountable. When violations of international law occur, this can be considered and addressed as such, and the uncertainties of concepts like that refer to systems of or orders that are based on otherwise non-specified rules can be avoided. In essence, the utility of let's say a rules-based international order that is premised on public international law comes down to three elements. Rules are important. They are a fundamental feature of human existence, and public international law has aimed to meet the challenge of applying rules to bigger and more diverse groups through the years. Rules are important not only for guiding behaviors, but also for setting expectations and thus helping mitigating the risks of conflict or misinterpretation. Second, a rules-based international order grounded in international law includes predictable mechanisms for updating or amending existing rule sets if there is a need. And third point is that despite limitations, once again, a rules-based international order which rests on public international law commitments also offers mechanisms for addressing violations of those rules or rule sets. So before handing over to the floor to my colleague Iris, I just wanted to make one final point, which is related to the second element that I was mentioning, basically the possibilities that a rules-based international order grounded in public international law offers mechanisms, predictable mechanisms for updating and amending existing rule sets. So nations in the Global South are working towards strengthening the institutions, enhancing legal frameworks, promoting accountability, and this involves addressing historical legacies of colonialism, economic disparities, but also reflecting and maybe putting forward ideas about partial changes of the existing rules through the mechanisms that already exist. So some of those voices we wanted to discuss and take account in our paper of some of those voices and perspectives. And in this regards, once again, upholding a rules-based international order, which is grounded in public international law, not only provides a legal concept, but also a vehicle for fostering cooperation and resolving conflicts, always within the instruments that are already available. Thank you. I will, yeah. Can you say?
First of all, thank you, Julinda, and thank you everyone to making it here today, and those of you who are online. So as mentioned before, I will be focusing on the African approach to the rules-based international order, which is multi-faceted and shaped by historical experiences, diverse cultural backgrounds, and geopolitical realities. So when we refer to the African approach, we are discussing the distinctive perspectives, values, and priorities which are commonly shared by African nations or emphasized by the African Union. And it is important to also note that we're seeing Africa not as a monolithic entity, but there is significant diversity among its nations. However, there are certain commonalities and overarching themes that we sought to identify. And in particular, today I'll be focusing on a few of them, namely sovereignty, multilateralism, collective security, conflict resolution, institutional reform, and development. These reflect the continent's aspirations for greater autonomy, inclusivity, and equitable participation in the global governance system. So starting with sovereignty and non-interference, the African stance within the rules-based international order is deeply rooted in the principles of sovereignty and non-interference, which are direct responses to the historical legacy of colonialism, the struggle for self-determination. So we regional bodies like the Organization of African Unity and which was later succeeded by the African Union, were formed to address shared challenges and foster regional integration. Central to these organizations is the principle of non-interference, which prioritizes respecting member state sovereignty and non-interference, and internal affairs. This principle is codified in key documents such as the African Charter of Human and People's Rights and the Constitutive Act of the African Union. So participation in regional as well as international organizations provides nations with avenues for conflict resolution and cooperation on various issues. This includes territorial disputes, natural resource allocation, and indigenous rights protection. So legal mechanisms such as the International Court of Justice have been instrumental in resolving territorial disputes, such as, for example, the case concerning the land and maritime boundary between Cameroon and Nigeria, which I believe will be addressed later on in the panels, in the panel discussion, I mean. So also, the International Criminal Court plays a crucial role on the one hand in addressing atrocities and promoting accountability. However, critics do argue that it disproportionately targets African leaders, leading to accusations of bias and neocolonialism. Despite criticisms, we argue that the ICC's victim-centered approach allows victims to participate in proceedings, seek reparations, and contribute to healing and reconciliation in affected communities. So moving on to regional and global multilateralism, African countries strongly support multilateral approaches to international relations and governance for several reasons. So it amplifies, for one, their influence in global affairs. It aligns with their principles of sovereignty, equality, and non-interference, and facilitates cooperation and resource sharing and mutual assistance in addressing common challenges. So regional organizations play a vital role in promoting unity, cooperation, and solidarity among states. These include, for example, the African Union, like I mentioned before, ECOWAS, SADC, etc. So furthermore, African countries value the role of international organizations, of course, the UN, which provides platforms for dialogue, coordination, and action, as well as they actively participate in institutions like the World Trade Organization and the International Monetary Fund, advocating, of course, for collective decision-making and cooperation to address global challenges. In recent years, African countries have been particularly engaged in multilateral efforts to address climate change and environmental challenges. They advocate for global cooperation to mitigate climate change impacts, secure climate finance, and promote sustainable development practices. Moving to collective security and conflict resolution, African nations often advocate for collective security mechanisms and peaceful conflict resolution processes within the framework of international law. At a regional efforts, there are initiatives like the African Peace and Security Architecture, which demonstrate Africa's commitment to resolving conflicts in the continent through African-led mechanisms with support when necessary from the international community. It is a comprehensive framework for managing, preventing, and resolving conflicts in the continent, consisting of a number of components, including early warning systems to identify and to also identify and evaluate possible conflicts and crises, preventative diplomacy, peace support operations, and post-conflict reconstruction and development. So in terms of international institutions, African countries frequently call for reforming international institutions to better reflect contemporary global realities and to provide African states with a more prominent role and voice. These reforms are aimed at making institutions more inclusive, representative, and responsive to the needs and priorities of African countries while addressing systemic inequalities in the global governance architecture. For example, they propose increasing the number of permanent and non-permanent seats on the UN Security Council and for it to also include African countries. In the realm of the international financial institutions as well, such as the IMF and the World Bank, in African countries seek reforms to enhance aid, debt management, and development efforts on the continent. Within the framework of the WTO as well, African countries propose various reforms to ensure a more equitable global trading system. For example, they emphasize the importance of integrating the development dimension in the WTO negotiations and agreements alongside capacity building initiatives to actively engage in trade negotiations and comply with trade rules. Further, in terms, and actually finally, in terms of development and economic justice, African states prioritize issues related to development, poverty alleviation, and economic justice within the rules-based international order. They advocate for fair trade practices, increased development, debt relief, and technology transfer to support sustainable development efforts. The UN Sustainable Development Goals, of course, alongside the AU Agenda 2063, offer a comprehensive framework for addressing socioeconomic and environmental challenges in Africa. Progress has been steady, as identified on key SDG targets, such as clean water and sanitation, affordable energy, and sustainable communities. Finally, I wanted to make another note, an important note that the Global South has led ongoing discussions and negotiations at the UN level on the draft covenant on the right to development. The idea for a legally binding treaty emerged during a summit of the Movement of Non-Aligned Countries in 1998 in Durban, South Africa. So interestingly, as highlighted by the chair of the working group on the right to development, Ambassador Akram, there is limited engagement with financial institutions like the IMF and the World Bank, as well as limited to no discussion with the Global North and the EU. But I think I'm going to stop here and we can start the panel discussion. But yes, thank you very much.